This plenary panel is designed to kick off the discussions for the 3 days. We have invited 3 speakers to join us to give their reflections and thoughts and to provoke some of the conversation. There are presentations from Meg Grace Maledu, who joins us in Johannesburg. There is an input from Associate Professor Sindiso Mnisi Weeks, who has sent a recorded input from the United States. And then we are joined by Professor Sonobi Lemnuana from the Eastern Cape. I will introduce each speaker before they speak, and that will also be a prompt to them to switch on their cameras and prepare to give their input. Following the inputs from the speakers, we will have the opportunity for engagement and questions. Again, a reminder, given the hybrid nature of the conference, we are asking that people please post their questions and comments on the chat. I will then have those fed to me from the venue that I'm in, and we will have an opportunity to put those to the speakers and for engagement. So without further ado, I'm going to introduce Meg Grace Maledu. Me Maledu is a member of the Lesetleng community, and she was the first applicant in the very poignant and impactful judgment handed down by the Constitutional Court, to which she gives her name, the Maledu judgment. So Meg Grace, you join us from the Johannesburg venue. Please go ahead and provide us with your input. A reminder again to those who are online that following the inputs from speakers, there will be a moment of pause in which translation will be provided at the in-person venues, and then we will resume with the following speaker. Meg Grace, over to you in Joburg.
Mata! Good morning, everybody. Nagi Meg Grace Maledu, ki tswa ko Lesetleng. Mo family nya bana ba le 13 ke wa bosupa mo lapeng la geso ke ka mo e leng gore re godile re dirisa mobu ko gae ntate o ne a lema re ja mashi re tsena dikolo ba sa bereke go baneng ba ne ba sa batlane le tšhelete bana ba batlana le botshelo go tswa mo lefatsheng ka jalo ra go la yalo re itse gore mukona o botlhokwa-tlhokwa ke ka mo irileng ge re bona lefatshe la rona le tsewa fela re sa bolelwe sepe ka ema ka dinao ka re e seng ntatemogolo ba re boleletse gore ba rekile lefatshe ke ka mo ka ema jalo ka ba ka ya ko tronkong ko Mogwase ka di 28 tsa June 2008 re tshwarelwa gore ge ke re a re se ke ra fa di minera lefatshe la rona ibile re sa itse ibile ba dira open cast nte re neng fatshe re bueng re direng ditumellano mme go ina le first removal ya 2014 na ka gana I have refused to be relocated on that time until re kry-a thuso mongwe wa batho ba ile ba nsupporta mo struggle ke sona bile monwana a le go le Gilbert ba re fa direction ya gore go ka etsagala eng. Now I'm not educated, but I understand what is right to my side. So mo kgweding yena ya bomme anke bomme re emeleng bana ba rona ka dinao a re ruteng bana ba rona gore lefatshe le botlhokwa e se ke ba dumella fela gore as long as I am working in the mine, how they're working in the mine after what they're gonna benefit after they took all the minerals out of our country. Women, let's stand up and fight for our future of our children. We born being black and we're gonna die being black. Let's not hesitate to come forward and battle for our future, for our children. And we must know that kantle go lefatshe ga ke batla tšhelete le ka nna lampa 10 million after ke e fetsa kolo ye ke rekileng ntlo e ke e batlang botshelo ke bo batla ko bo ba fa kae ke sena lefatshe ke potso sentse re ipotse pele gore ga ke batla tšhelete ke sa batle lefatshe go e dirisa fa kae motswana wa lema ba gaetso a re leme re iphidise re ijise ga o tloga gona yaanong o ya go di mmarakeng go di marketeng like ko lapeng kwa go na le di-market ko Northern, Flay Central, di tsena every day, kgomo ka tšeko ke 15,000, tomorrow is 20,000. E tshwanetse e nne fa kae kgomo ye, e tshwanetse e je eng. Ebile ke ikopela from government, the Minister of Rural and Environment, to come and assist us in the land. We don't have place for grazing our cattle and so forth. How are we going to live without the land? How are we going to be people without the land? We can't stay in water. And even water is on the land. Everything is on the land. So I am here to say to the woman of South Africa, forward we go forward, so that the parliament of our government must know that we need the land. We need their support. We need the earth dams in our land so that we can have everything, because we can irrigate at any time. We can do things at any time when we have water. Like for instance now, we don't have water. We don't have electricity. We don't have even, we want to talk to somebody with phone. You can't, because of pressure we are having. Our government, I am appealing to you that know that we are people. I am a single parent with 5 children. I have survived with to send them to the school because of farming and everything you know from the land. Because of the land. I'm still saying the land. Because I get ke tlo go le bolella gore ba gaetso a re se bueng ka tšhelete, a re bueng ka lefatshe. Rona batjha le ko kae, lona batjha tlogelang go tsaya di-stene le aga di-room tsa go hirisa gore o kry-e tšhelete. Your grandchild o tla dula mo kae, because the land will be finished. And galo lefatshe ga le tloge jaaka re ka kgatha lone, jaaka re ka kgatha setlhare se be se tloga. If you misuse your land, you are nothing at the end. So people, let's stand up for our land. From left to right, forward we go. Amata!
Thank you very much, Meg Grace, for that powerful input and kicking us off in such a powerful spirit. I now have the pleasure of handing over to the technical team to play for us the input by Sindiso Mnisi Weeks. Professor Mnisi Weeks is a professor of law and society at the University of Massachusetts in the United States of America. Because of her schedule, but also because of the time difference, she is unable to join us live and has sent a recording of her input for us to share with everybody today. Apologies, actually, I'm just wondering if I should take a pause for translation in Johannesburg.
Yes, Megaeche.
Thanks. Ausconi Tepo.
Oh, thank you very much. In short, Mrs. Maledu is saying, I am Maledu. I'm Mrs. Maledu from Lesetleng. I stood up against the relocation of our community without our consent. I was imprisoned in 2018 in 2008 for doing this, and I appreciate the support that I got from, in particular, Dr. Sonwabile Mnwana and the others, and I was I ended up going to court, and I want to encourage the women who find themselves being labeled widowed or vulnerable to not shake up, to not be frightened by the thing, but they need to stand up and fight for their land. She's sending a very strong message to those who want to accept cash compensation instead of land. That even if they give you 10 million, there's nothing you're gonna do about it because it will fade away like a mist. But if you opt for land and you fight for your ancestral land, you will be able to survive. You will make a livelihood. She's making an example that as a single mother, she was able to take her kids to school and he still can eat and provide for her family because of the land. So if we give up the land, the struggle for land, we are giving up our future. So we're not only fighting for the current generation, but we're fighting for the future generation. So a strong message here is to women and young girls to make sure, and the young people, to make sure that they are not fooled by a number of millions in the bank, but they fight for their land. Thank you very much.
Thank you very much, Ascani. I'm going to then take a pause for translation at the venues. So I'm going to give 5 minutes for translation at the venues themselves.
Nesibindi ningesabi.
Sorry, Derwin, you were on mute earlier, so we only got the last part of your translation. Apologies for that. Would you kindly speak to the audience again? Thank you, sir. You're now unmuted.
Ngithi ke isikhulumo besisuka lapha ngaphambilini umama uMaledu okungomunye owabangali owayephambili efake icala lomhlaba enkantolo yomthethosisekelo. Yena ke uthi abantu besifazane nje bonke ababe nesibindi ukuthi bahole imizabalazo yabo lapha eindaweni zabo lapha abahlala khona. Uthi ke futhi bangalahli umhlaba wabo ngenxa yokuthenjiswa imali noma kuthiwa bazokunikeza u10 million. Lo 10 million uyofana nento engekho nje. Efanele uyogcina ungayiboni ukuthi yenzeni kanti yena umhlaba uthi usebenzisa umhlaba ngoba uyohlala ukhona uthi yena ukwazile ukufundisa izingane zakhe ngokulima ngakho ke uthi nezingane zingavumi ukuthi kuthengiswe ngomhlaba wazo noma zilahlekelwe umhlaba wazo ngoba sithi zona ifuna amathuba emisebenzi ngoba konke lokho kuyinto yesikhashana kanti umhlaba upheli uthi ke ngakho ke yena uyanigqugquzela ukuthi ningesabi ukulwela umhlaba yini kakhulukazi abantu besifazane uthi njengamanje manibheka nje amanzi awekho ugesi awukho uhulumeni akasizi ngaluthe into eningi uthi asikwazi nje ukuxhumana ngamafoni njoba nibona nenetwork ingekho kunzima nokuxhumana nje nabanye abantu uhulumeni akasizi lapho kufanele ngabe uyasiza khona ngakho ke uthi uyanigqugquzela nonke ukuthi sukumani nilwele umhlaba wenu ningesabi nibe nesibindi njoba yena uthi uze ugcizelela igama lithi yena nje akafundile kodwa uyawazi amalungelo akhe
Thank you very much. Just for clarity, the translation is just for the in-person venues. So there is no need for it to be broadcast on the Zoom platform. The idea is just to ensure that those who don't necessarily speak the languages are able to follow and participate. I'm going to then move to the input from Professor Sindiso Mnisi Weeks, who is a professor of law and society at the University of Massachusetts in the United States. As I indicated, she's unable to join us live, but has sent through a recorded input that will be shared with us. And then again, we will follow the same procedure. There'll be a pause of 5 minutes for translation purposes at the in-person venues. Melody, please go ahead and load the input.
Good morning, Sanbonani. My name is Sindiso Mnisi Weeks, and I'm honored to get to share some thoughts with you this morning as we kick off this conference. This is very exciting for us and important, of course. So I was very honored when my colleagues at the Land and Accountability Research Center invited me to present my paper, but I was also a little bit surprised because I feel like this paper can only really sort of very loosely be considered a paper on property or land, because it isn't strictly about that. In one sense, it's really a paper, it's different papers actually that were combined. On one hand, it's a discussion of the progress that was made by the Constitutional Court in the way it developed the customary law concerning the proprietary consequences, that is, the property-related consequences of marriage. On the other hand, it's a discussion of how the progressive amalgamation of customary law and common law by the courts could present the productive path to achieving transformative constitutionalism as pragmatically as possible in South Africa. And these two themes are sort of held together by the argument that the Constitutional Court has been on a positive trajectory in its approach to customary law that is demonstrated in the Ramovi case, or Ramovi cases, and provides a feasible platform on which to build such an amalgamated future South African law as the court itself has previously expressed to be the Constitution's vision for South Africa's future. So, Ramovi 2 was a case that the paper starts out describing as having originated from initially, actually Ramovi 2 itself was the unsuccessful, though unopposed, application of the Minister of Justice to have the court delay the effect of the declaration of constitutional invalidity that the court had issued in Ramovi 1 by a further 12 months. And what had been declared invalid in Ramovi 1 was Section 7.1 of the Recognition of Customary Marriages Act of 1998, which left customary marriages entered into before the Act out of its protections. As the court observed in its judgment, this matter had actually been litigated before in Gumete in 2009, wherein the court had said the exclusion of monogamous marriages entered into before the Act's commencement was unconstitutional. At that time, the court had refused to rule on polygamous marriages, but flagged the issue for the legislature's attention, and now bemoaning the bait and switch of Section 6's injunction on the equality of spouses being followed by Section 7.1's exclusion of some marriages, the court was returning to extend the application of its finding in Gumete to polygynous marriages. The court was still kind to the legislature and executive, though, allowing it a further 24 months to remedy the matter, while still giving the applicants tangible relief in a temporary prescript that gave wives and husbands, quote, joint and equal ownership, including joint and equal rights of management and control over marital property. Yet, the court drew a distinction between house and family property, and this is what is partly of great interest in this paper. In this sense, the court set right not just what had been left hanging by Gumete, but also by Bear in 2004. So Bear, of course, has met with some criticism for having not considered the customary context, especially as relates to, firstly, the particular values that are emphasized in customary law, such as multi-generational provision for survival, how property is customarily conceived, used, and shared in nested and overlapping units and spheres of social organization. And furthermore, the fact that women don't only feature as wives and children in customary law communities, but they also appear as other kin and relatives, and in fact, security is at stake for all of those concerned. The judgment attended to some of these concerns, but also channeled some of the sentiments that the court had captured in Maledu in 2018, when it emphasized the importance of landed property for the livelihoods, survival, and thus dignity of members of customary communities. In particular, the Ramohovi Court in Ramohovi 1 took seriously the various configurations of customary familial and social organization and the values that inform their proprietary relationships. So in paragraph 60 that's quoted here, you see how the court valued the multi-generational emphasis in customary law, as well as the relationship between subunits of the family and their respective dependence on landed property. Moreover, the court spoke specifically to family property and situated it in the context of the various nested and overlapping units that constitute a family. And if we look back, when it had been presented with similar complexity, there, the court had found that it was unable to enter into such nuances as expressed in the Ramohovi case, partly because it said it did not feel that it had enough information on the changes that were taking place in customary communities on the ground to make a determination as to the best way to develop customary law. And it therefore elected to, quote, develop customary law by means of what it said was a temporary replacement of its content with modified content from a civil law statute, which the legislature then made permanent through what was subsequently referred to as a customary law statute, even though it had drawn from civil law content previously. By contrast, the Ramohovi 1 court identified the nested systems of social organization that exist in terms of living customary law and their corresponding rights to occupy, use, access, as well as manage and control real property, that, or more specifically, land as property. The court then made a plan for how to honor the constitutional demand that all parties have equal rights by appealing to the values and norms that exist within customary law itself, and therefore using customary law's content and values as the primary resource from which to derive solutions on how to strike a balance between custom and the Constitution. In other words, sort of put differently, the Ramohovi 1 court boldly waded into the nuanced complexity of living customary law and the social and proprietary relations that exist in terms of it in a way that the bare majority had hesitated to do. While maintaining that Ramohovi represents tremendous progress in how the court treats customary law, I argue in the paper that it still fits within an imaginary in which customary law is separate and other than the rest of South African law, especially the common law. And so the crux of the paper is the argument that amalgamation of customary and common law is more feasible than many people think. And so in that vein, the paper starts with the argument that harmonization and amalgamation are actually not really radical ideas because, to start with, the common law and customary law are essentially similar in nature, particularly if you consider how living customary law becomes official customary law through formalization and institutionalization and professionalization. And additionally, both customary law and common law are historically very deeply entwined in South African law, especially if you look at the roots of official customary law and the common law. And so it is somewhat artificial to think of especially official customary law and common law as separate to begin with. Still, I acknowledge that there is the reality of technical and adaptive challenges to how amalgamation could possibly be achieved. And I first start by attending to the technical challenges by returning to Z.K. Matthews's breakdown from way back in 1934, in terms of which I argue that we should understand that Z.K. Matthews's option 1, specifically that customary law ceases to exist, is actually only going to be realistic if I should take that back. It actually isn't realistic to begin with, because living customary law's existence defies any formal attempts to abolish it, because it is ever evolving and adapting. So actually, the customary law ceasing to exist scenario is only possible for official customary law. Option 2, according to Z.K. Matthews, is that customary law develops as a separate system of law. And I argue that this is always going to be the case with respect to living customary law, because that's always just, continuing on its own trajectory based on how the communities themselves develop it. But the legislature and courts do have a choice on whether to integrate official customary law as state law or not. And that's part of what I'm sort of really thinking about in this paper. And then option number 3, that customary law is united with common law, I argue is what actually constitutes amalgamation rather than harmonization. It's the true amalgamation. And as I point to in the slide, it's possible to do this with living customary law, but is limited always by the result being that those parts of living customary law that are amalgamated thereby become official customary law by necessity. Needless to say, what is meant by amalgamation is the integration into a single system of law, which is basically what the Constitutional Court had outlined as the constitutional vision in Alex Court in 2004, when it noted that customary law is not subordinate to the common law, but of equal status under the Constitution, and then added, quote, in the result, indigenous law feeds into, nourishes, fuses with, and becomes part of the amalgam of South African law. And as I point out in this paper, this language suggests more than the parallel system of law under a single overriding constitution that we currently have. So with that, then, I turn to the adaptive challenge of amalgamation. And in the paper, I canvass the arguments presented on both sides of the scholarly debate on whether we should or shouldn't amalgamate. And these arguments include concerns that, firstly, living customary law's content would not be well understood and respected in an amalgamated law. And I argue that even though this is true in principle, in this respect, Shilibana and Mailani both decided, well, Shilibana in 2008 and Mailani in 2013, by the Constitutional Court, actually made significant progress by clarifying how courts should determine the content of living customary. And then secondly, living customary law, the argument is made by people opposing amalgamation that living customary law would not be assigned its due value in the amalgamated law that is produced. And in this respect, I point out that the concern is that living customary law's process and context need to be well understood and sufficiently weighted, and probably wouldn't be in an amalgamated system of law. And I argue here that actually there are tools within the laws that exist, including even precedents that draw upon the common law, such as, or that focus on the common law, such as Bar case and the case from 2007, which provides an analog here, I think, for considering, as the court spoke to, quote, the relative situation of the contracting parties in light of the potential injustice that may be caused by inequality of bargaining power. And so here I'm arguing that, in a sense, the court has this sensitivity that it has developed in its jurisprudence. And so we could draw upon this as a way of sort of thinking about making sure that process and context are well understood and sufficiently weighted with respect to living customary law, as the court argued should be done even in the treatment of common law content. So the paper then emphasizes the importance of realizing that for the protection of living customary law, process, specifically consultation and consent, is actually more important than content. And this process is what the Interim Protection of Informal Land Rights Act of 1996 tried to capture and align with the Constitution, and it is clearly defended in Maledu. And this process has been described, using words like fluid, flexible, malleable, nuanced, and negotiated. And I argue that this process may also be most central to the argument for the feasibility of amalgamation, because the ideas of a normative repertoire and paradigm of argument as the means by which interpersonal negotiations are expressed when drawing on the variegated norms that make up the living customary law, those are not unfamiliar to the common law. And further still, the conceptual framework that these concepts of, normative repertoire and paradigm of argument provide, this conceptual framework could form the common foundation for the amalgamation process. So, in the end, my paper turns to the question of transformative constitutionalism. And I say, I start out by defining transformative constitutionalism, putting it in the terms that Carl Clare initially used to present the concept, and argue that legal amalgamation based on living customary law processes and values effects a new imagination, quote unquote, of legal method, analysis, and reasoning that's consistent with the Constitution's transformative goals, as well as a transformative conception of a judicative process and method. Or in the words of the former Deputy Chief Justice Musameke, the judiciary's, quote, observing unfailing fidelity to the transformative mission of the Constitution. So that's what transformative constitutionalism refers to. And then I asked the question, if the amalgamation of living customary law and common law isn't transformative, then what is it, right? Because if only as a matter of degree, the proposed amalgamation would be a deeply transformative step for the courts to take. And yet it is still highly plausible. In fact, because it does not require, firstly, codification of living customary law norms, because that is an impossible task at the best of times. We have a long history in South Africa of trying that, and we know that it doesn't work. Secondly, it doesn't require radical retraining of judges to become living customary law content experts, which would be extremely difficult and time-consuming at best. And thirdly, it doesn't require more living customary law research than is already necessary under the current choice of law system, although maybe a higher frequency of use of those skills, which I argue is actually appropriate within the context of South Africa. So if those are the things that are not required, then what is required? What's required is the court's openness to being presented with innovative and unfamiliar arguments, drawing on the social science evidence of the living customary law in any and every case where the South African public takes the court up on the invitation to draw from any and all of South Africa's normative traditions to make a constitutionally adherent argument. So once the court is presented with these arguments, the courts would need to use the schema that the Constitutional Court has already established, most recently in Ramohovi, and thus deeply integrate history, political and social economy, the original purposes and objectives of the living customary law norms, and how those fit in with the current versus historical context, and then the contemporary implications of applying those norms, especially within the context of the parties' relative power and status in the court that they are, in the court case that they are presented with at the time. And again, here we're remembering the precedent that was set by Barkhuizen. In sum, this might mean that the courts would be invited into being more mediators than adjudicators, and thus being allies and co-strategists with the parties to the cases that come before them. This would amount to the courts integrating living customary law values into their own practice. And why? Well, because Ubuntu, or in the Sotho language is Botho, when applied to the role of courts and judges, amounts to an engagement that, quote, reconceives rights as relationships and courts as the mediators that help to structure the relationships that foster autonomy, unquote. And these are the words taken from Jennifer Nadelsky in her argument for us to reconceive rights as relationships. In a sense, Maledu applied this very principle to customary land, and Ramohovi sought to do similarly in its approach to the proprietary, that is, the property-related consequences of marriage and inheritance. And I'm arguing that amalgamation would mean applying this principle to the role that courts play in transforming all of South Africa, both its laws and its society. And with that, I will leave it there. And thank you very much for your attention. And I will just point out briefly that for those who are interested in, having follow-up conversation about this, please, by all means, feel free to email me. And if you'd like to read the paper itself, it did appear in the Constitutional Court Review of December 2021. Thank you.
Thank you very much, Melody. Colleagues, we apologize sincerely. We recognize that the sound quality on that clip was not great, and it made it quite difficult to follow Professor Nisi Weeks' presentation. I'm going to ask our colleague Wilmeen Wickham to speak briefly and offer a summary of that presentation, just to ensure that people are able to glean some of the top points, given that it was difficult to follow because of the bad sound quality. Wilmeen?
Thank you, Nalindi. Can I just get confirmation that you can hear me?
Yes, we can.
Thank you. I'll try and very briefly just summarize the key point of Sindiso's presentation for people who were unable to catch it, and I think it provides a very important framing of the conference. So Sindiso was talking about the problem of dealing with customary law as a source of law within our South African legal system, where we have statute law, but in particular common law, and how to deal with customary law next to the common law. And she talked about earlier court decisions where we've seen that where customary law is not considered when decisions on the common law are made, where it is relevant, that you sometimes see decisions that inadvertently do not recognize customary law relationships and rights. And so this is the problem we are facing, to understand how do we incorporate customary law as a source of law into the South African legal landscape. So she talks about 3 different possibilities of doing so. The first is, she says, to combine customary law and the common law, and thereby codifying the content of customary law. She says that is not, in her mind, preferable, because in codifying customary law, you turn it into official, static customary law, and thereby kill living customary law. So she talks a lot about our understanding of customary law, also the court's understanding of customary law, that it is a system that evolves, that is flexible. And so when it is codified, so when it is combined with the common law, then you eliminate the possibility of customary law to evolve and to be flexible. So she puts that option aside. The second option she mentions is to treat customary law and the common law as completely parallel, separate systems, and to apply them separately. But when we do this, it does allow the living customary law to continue to evolve, to be flexible. But the problem with that approach is that you then do not infuse the common law with customary law principles. And it is in those cases that you can get common law decisions that inadvertently make customary law rights inapplicable. And so the parallel model is also one that she does not argue for. The third option, which is what Sindiso is arguing for, is amalgamation of customary law, living customary law, and the common law. So this is a model in which customary law norms and rules would infuse the common law and vice versa, which is something that we see happening on the ground in any event. Now, she does point out that there is a limitation that this amalgamation will inevitably mean that some aspects of customary law will be codified, but if within the transformative system that she envisions, that this is acceptable. So she talks about how to realize this amalgamation of customary law and common law. And she says it requires a radically transformed judiciary. It requires courts that understand customary law and its values, courts that are able to draw from plural normative traditions, so from customary law and the common law. She says this is not unusual in our South African context. We have common law jurisprudence from the Constitutional Court that calls on contextual interpretations of common law. And in the same way, she says, she would argue for customary law to be able to infuse the common law in this amalgamation. And what it really requires, she says, is a different role for courts. So for courts not to only be adjudicators, but co-strategists. And we have seen examples of that in our jurisprudence. She mentions Shilubana and Mayelane. Yeah, I'm going to end there. I hope that did her a little bit of justice. Thanks, Nalini.
Thank you very much, Philmin. We're going to take a 5-minute pause for translation at the in-person venues.
To summarize taba ya ga Velmin, because Sindiso na le ka pele and lentswe la gagwe le sa utlwane sound le se sharp. So o re Sindiso o bua ka molao wa rona wa setso le gore ga o ka kwaliwa e tlo nna gore o tlo fetolwa, because molao wa setso it's about consensus, it's about ditumalano. That is why gantsi go ya ka lebaka leo le go buang ka lone, and then batho ba dula fase ba dumalana. So re tshwanetse ra ga treatiwa melao e be a kere go na le common law le molao wa setso. Common law ke o kwetseng o dirisiwang ke dikhoto are tshwanetse gore ke melao e mebedi e farologaneng. And then it's only treatiwe yalo e le separate, because ha ba ka re ba e kopantsha ba ka re okay a re amend the common law gore re cater for customary law, re tlobe re bolaya molao wa setso le mokgwa wa teng wa gore molao wa setso is about consensus, ra dumelana a re ka so se kwetsweng ra se fetola. And ka mabaka a ha batle gore common law ha re ra di kopantsha e bola e customary law, so o nagana gore maybe di tshwariwe di le separate fela yalo. And then gape ga a ajwe gore di tshwariwe di le separate because of ha nagane gore e tla be le mokgwa o tla re tswelang mosola, mare o ajwa for amalgamation. So ha re amalgamation ra tlhakanya red and blue and then re tlo kra color engwe, but wa tshaba gape gore ha king e tlo ba strong than it, color e tlo ba strong than the other. So o tshaba gape gore a ka etsa ore there's a limitation gore go tlo ba le limitation ya tse re ka di kreyang a re ka re ra codify. Go codify ke go kwala fofatshe, like molao wa setso wa rona ha wa kwalwa fofatshe. That is why gantsi batho ba dira dilo o tseba lenyalo le berekiwa yana, the next thing go ba di dira ka mogomong. So and go sa kwalwa go ga teng gore fa matla a gore ya ka re le batho ba re ipele molao re o change ka mo go re o batlang re yana ka gore ha o kwetse fatshe re tlo nna re boela go morago re sa tlhabologe. Ore ga ile gore dio tse di ka amalgamatiwa go ya ka Chilubama le Maelane case, go ke di case tse di winnweng ko court go dirisiwa customary law. Ore ga ile gore di ka kopantshiwa go tlo tlhokega gore judiciary e fetolwe gotlhelele, and go tlo batlega gore role ya dikgotlatshekelo
Thank you very much, colleagues, and thanks again to Wilmeen for that summary. We're going to move then to an input from our third speaker on today's opening plenary, and that is Professor Sonwabile Mngwana. Professor Mngwana is a professor of sociology and joins us from the Rhodes University, Upper Eastern Cape. Professor Mngwana, I hope you're there. Could you switch on your camera and microphone, please? I think you're on mute.
Hi, colleagues, can you hear me? Can you hear me, Nolund? Can you hear me?
Yes, we can, Professor.
Thank you very much. I am grateful for this opportunity and thanks for the organizers of this event to have invited me. I am thrilled to see Mama Ledu, that she hasn't aged a bit since we last met, and her marvelous militants still exist. And I'm quite grateful. I was very inspired by both speakers who have spoken before me. I'm just going to speak briefly on what I sort of gave a title, Disempowered, Dispossession and Conflict on the Platinum Belt. So I take the case of Platinum Belt to sort of look at issues around mining and dispossession, which is part of the work that I've been doing for several years. I think in this big conference, which is titled The Failed Promise of Tenure Security, the promise of tenure is one of the key issues that epitomize the contradiction at the core of South Africa's democracy. The Freedom Charter, almost 3/4 of a century ago, promised that all shall have the right to occupy land wherever they choose. This, in my view, is a stronger promise and an assertion than the other famous sentence in the Charter, which says that the land shall be shared among those who work on it. The latter tends to limit the understanding of what constitutes land and its diverse meanings. It also confines the meanings of land to a productive asset, that is, property. I hope the rich discussions that will be carried out in this conference will seek to broaden the focus beyond this narrow focus. In South Africa, perhaps more than anywhere else in the African continent, land conflict has long been a major cause and an outcome of unparalleled dispossession and racial inequality. As we know, I think arguably the Southern African region has been the most affected, especially Black people here were left after this colonial dispossession with no land where they could lay their feet. So for nearly 2 decades, I have examined the social shifts that have characterized the territorial expansion of mining in rural South Africa and the significant impact of mining on communal land, so-called communal land, in the former homeland areas. And I have observed the struggles that mining has produced. So in this paper, I detail the intense local struggles over mineral-rich land in the villages that spreads over what is called the Platinum Belt in the Limpopo and the Northwest provinces. So I primarily focus on 2 themes. One is the theme of dispossession, and the other one is conflict. I think we are all familiar with dispossession. I've already touched on the colonial dispossession, but I argue in most of the work that I've done that mining has added another layer of dispossession in these areas, whereby vast tracts of land, including communal communities, have been fenced off, and other land that was used for arable production have been fenced off for mining, and at a very rapid pace. And this happens, I argue, because of a collusion between mining capital, the chiefs, and the state. And new forms of forceful relocations have occurred, especially in Limpopo, and even in the Northwest. I mean, Mama Ledu has highlighted their struggles. So if one observes the life in the Platinum Belt, it is a life that is characterized by precarity. So rural residents do not know really when will be the time when their land will be targeted by mining and they will be forced out of their land. And there has been massive eradication of customary land rights and poor recognition or non-recognition whatsoever of pre-existing rights on land, including the history of group land buying, which was quite dominant in the area, during the 19th and the 20th century. And these are some of the things that have led to significant conflict. So, I mean, I think that when we talk about conflict on the Platinum Belt, I can highlight just two things. There's been a lot of violent protest against mining, and Mama Ledu has highlighted how they have fought in the courts of law, resisting being dispossessed by the mines. And I've encountered, in many parts of the Northwest and Limpopo, women and men resisting to be relocated from their land, even when mines were really expanding to their land and even destroying their homes. And the chiefs have been colluding with the mines. Now, I'm not going to go in detail over the history of how this took place. For instance, the native land laws and how the apartheid state colluded with tribal authorities, the so-called tribal authorities, to disempower Africans. What I'm going to focus on mainly is two issues. One, I want to talk about the concept of power and the concept of community. I detailed the analysis of how the configurations of power at a local level can help us to better understand local conflict. But power, I argue, it has its own ideological origins. And I argue that disempowerment on the Platinum Belt has ideological origins. So colonial dispossession and the wholesale disregard and suppression of African indigenous landholding system, denial of property rights, and enforcement of cheaply mediated community rights, so-called community rights, and ascriptions of tribal identities were the key elements of what scholars like Mahmoud Mamdani highlighted as the indirect rules, how the modality and the model of indirect rule was enforced gradually in colonial Southern Africa. So this system was influenced by the demand for migrant labor, especially in the case of Southern Africa and South Africa, And to enforce political control, it was justified, according to some scholars, by the social Darwinist thinking. And according to this thinking, colonial officials perceived land rights within the African population to be communal in nature. And since African peoples were seen as being at a lower level of social evolution, so private property was seen as a mark of civilization, and Africans apparently were not part of this so-called civilization. So social Darwinism was applied vigorously in the colonial states, particularly in the late 19th and early 20th century, on land policies that were directed at addressing the African land tenure question, which in fact was the process of disempowering Africans altogether. So of course, the effectiveness and the character of this application, particularly when it came to the indirect rule and the power of chiefs, varied from place to place. For instance, in the Cape, for a limited period, Africans were permitted to purchase private property and as a form of individual tenure. And this was pursued for quite some time. But as indirect rule and segregation policies and this ideology took hold in the early 20th century, the defective notion was promoted, the notion that all Africans were now subjects of chiefs, and thus they were members of tribes. So in South Africa, the colonially derived version of custom and governance mechanisms, although legally ambivalent and administrative laborious, were to be kept intact and sustained through colonial declarations and the so-called native land laws. So that's one aspect in which power took hold historically. But I also draw on recent literature on power. I argue that there are limitations in the empirical understanding of how local claims over property are expressed socially and politically. For instance, Catherine Boone argues that in all political economies, property rights lie at the confluence of political legal order and the economic order. And as such, all rights, for all rights to have to be sanctioned by a legitimate legal authority in order for those rights to be effective. So for Catherine Boone, poverty and wealth accumulation are directly connected to access to land and natural resources. And she offered a somewhat robust sociological definition of property. And she argues that property rights are social relations concerning access and use of things, including land and land-based resources that sustain livelihood and society for most of African society, for most of African population. Now I draw on a more complex definition and explanation of African property systems. For instance, Ogendo opens up a debate by arguing that tenure regimes cannot be adequately explained by directing the inquiry into whether African social systems knew or even recognized the institution of ownership, and whether, if they did, that ownership was absolute or corporate, and who in society, was it the individual, was it the chief, or was it the family, or a clan, or a lineage, or the tribe, who was the repository or the custodian of this form of ownership. So this is a very helpful, in my view, point of departure in understanding the diverse meanings of property in land in African contexts. Ogendo even overemphasizes, even criticizes the overemphasis on the physical characteristics of land, for instance, the size of land and the physical space. He argued that this should be avoided. What constitutes property, according to Ogendo, is invariably the product of a social milieu in which we live, rather than any particular aspect of it. I think that's a very important point. This approach, which goes beyond the dominant orientations of understanding the character of property in land and land-based resources, is useful to understand the nature in which primarily sought to understand the character of mining-led development in South Africa. And in fact, even the way in which we documented the claims over land in our research. So Ogendo's model on African property systems of tenure is centered around the understanding the intricacies of power, in which he highlights two pillars. The first pillar is that the processes and the institutions that decide on allocation of power over land and land-based resources to individuals and even to smaller groups. The second aspect or element of Ogendo's theory of power is concerned with the processes that deal with local mechanisms of control and how power is vested within societal members in a particular group. So which means that who has power to decide on which land. I go on and on in this discussion on the paper. I'm not going to go deeper into this theoretical account. I'll go quickly to the final concept, which I think is very important, actually the notion of community. I think I make an argument in this paper that we need to shift from defining communities. I think we need to shift towards an understanding where the principle of community applies. Because in what we have written about and what we have looked at is how community is defined. For instance, we have argued that the fact that rural residents have consistently been defined as communities or even homogeneous tribal groups whose interests are controlled by chiefs and whose land chiefs can make decisions. I find that quite problematic. I think we need to look at a community as a principle. So I argue that community is one of the oldest terms, particularly used when referring to collectivities or groups of people. It is yet still very popular in modern conceptions and distributive claims and practices in Southern Africa. It is malleable, elusive term in both policy and especially in contemporary distributive claims over land and natural resources. And rural residents in the former homelands are generally referred to communities, and to be more precise, they are referred to traditional communities. And remember, these definitions are definitions and that comes from above. So this term, particularly its popularity and interpretation, is that Africans in rural areas are assumed to be collectivities. And in essence, they are ethnic groups with a common history, culture, and identity. And quite disturbingly, the grouping of Black people in rural South Africa into traditional communities through legislation has led to problematic apartheid-style interpretation of customary law and policy practice, where rural residents are regarded as subject of local chiefs, whose interests are communal, even in land-based resources. And this has elevated the power of chiefs into custodians of communal land. So an analysis and an explanation on local conflict in these rural locales is inadequate, as long as we continue to want to define communities, to want to define which community. Because I argue that we need to look at the notion of community different. In this discussion, I go beyond the notion of community as a collective identity, an identity which is usually imposed from above to people who are not given an opportunity to define who they are. Community is not just a form of social organization or a cultural identity. I argue it is a shared principle. I draw primarily on the work of the philosopher Gerald Cohen. To Cohen, community is the principle of socialism, together with another principle which he uses as equality of opportunity. It is not the latter which I focus on, but the principle of community. My rationale for expanding the notion of community as a principle is that the key argument laid in this work is that distributional claims over land, especially on the platinum belt, are rooted on demands by groups and individuals for a share of wealth. So, and however, the prevailing definition of communities as a tribal group with rigid customary systems does not capture the local context, nor does it open up what I call organic opportunities for sharing or distributing wealth, nor does it allow the emergence of fairly egalitarian spaces for equal participation in decisions about distribution of mineral wealth and sharing of resources, which exists in African customs, by the way. So this is the distributional impasse which escalates conflict on the platinum belt. Most important underlying most important, underlying the principle of community, or an understanding, in fact, what underlies the principle of community, will help us navigate the aspects of the principle and apply it, particularly in aspects where it applies in management and control of customary land rights. For example, the fact that many rural communities regard themselves as a community does not automatically translate to customary land holding systems, that all land and all their rights should be held communally. So the principle of community is central in defining resources that are shared within units and even in processes in which such resources are defined and shared. So then I argue that we shouldn't focus on which definition is wrong, because what has happened is that we have argued that definitions of communities are wrong. And even in legislation and in court cases, courts often focus on how a community is being defined. How do you define a community in the context of distributing land rights, and how communities are defined by custom? But the principle of community exists beyond Black rural residents. I think principle of community and how people become community in a particular context, even in urban areas, even everywhere, it is beyond the notion of custom or only confined to rural areas where Black people live. So this is, I think, the most important point of departure we need to look at, instead of looking for how to define communities in order to distribute wealth, and who, I think that especially the legal approach of defining communities, we should look at where do people apply a principle of community. Do they apply it at a local level, at small units, at the family level, or beyond that? For instance, do they apply it when they refer to rangelands? Do they apply it when they focus on water resources? So I think that is the point of departure with problematizing the notion of community and looking beyond the approach of defining, but towards an approach of looking for a principle, for a community as a principle, not a community as a form of identity. Thank you very much.
Thank you very much, Professor Mnwana. Colleagues, could I just ask the Goedgevonden Community Committee to please stop sharing your screen? I think we're viewing a screen that we shouldn't be seeing. Thank you so much, Sonobile. I'm going to pause for 5 minutes again to allow for translation at the venues, after which we'll move into the Q&A component of this plenary. Again, a reminder for those who have questions, please put them into the chat function. We are monitoring the chat and will engage with the questions and comments as posed in the chat function. So I'm just going to take a moment to allow for the translation process.
Dumelang bagolo. Ke a utlwana. Ntate Sonobile Mnwana le mone a ne a bua fale ke tlo sosobanya fela ka re ke taba e telle ba re fa 5 minutes. O thomile ka gore o thabile ge a bona le bomme Mamelodi ba bua fale dibui tse di buileng pele ga gagwe, ene a re o tlo le ka go bua ka taba ya disempowerment gore tsaela matla setšhaba se tsaelwa matla le go se tlosa mo ba nnang teng le di phigisano go se kwane ga botse gore dintho tse di tlisang tlhakatlhakano mo setšhabeng gagolo a bua ka Platinum Belt gore moruo o le wa go tloga Northwest go tsena Limpopo a ke re la tseba re ke di mine go tlhelele tsa platinum. A bua le ka gore tenya security gore re be le tshireletso ya naga le gore naga e le sesupo sa gore ke ya rona e botlhokwa thata-thata. A bua le ka gore tenya security gore re be le tshireletso ya naga le gore naga e le sesupo sa gore ke ya rona e botlhokwa thata-thata. A bua le ka gore tenya security gore re be le tshireletso ya naga le gore naga e le sesupo sa gore ke ya rona e botlhokwa thata-thata.
ene jwanong a tla mo tabeng e nngwe a re go na le taba ya gore ka jeko go lebeletse gore ha re tsamaya ka molao o le wa charter, the freedom charter, ba re naga ke a bao ba tla beng ba bereka mo go yona. Ga re lebella bonneteng le kgale a re naga ke a bao botlhe ba tla bang le ditokelo tsa go nna mo go yona mo ba leng teng le mo ba batlang go dula teng. A re tlhaloso e ga se e tsamayang pele. Ge ba bua ka naga ba bua ka thoto, kore ka Sepedi re re ke thoto go tshwana le ntlo, property. Empa ga go bjalo. A re go na le ditlhakatlhakano tsa naga tseo di tlisiwang ke semorafe, ke tla kopanya dipolelo, semorafe le go tšeelwa dithoto tsa gago. A re mengwaga e 20 a ntse a berekana le go tloga ko magaeng ke gore di homeland tsele tsa kgale mo go leng dikgosi mo rileng ra tloswa teng. Mathata a mang gore o bo Northwest le Limpopo. A re go na le gore ba re mathata a tliswa ke di-company tsele di tlo mainang. Empa go na le seemo se seng go gore level e nngwe e go e tlisiwang ke mine e go re boneng le rona re tsebang gore magosi a utlwana le puso le taolo ele ya pele ene e ya go magosi ba buisana le bona ba utlwana go felletse batho ba setse ba tsetswe matla le dithata tsa bona ba tlosiwa mo dinageng tsa bona. A re mme o re bontshitse mme Grace naga e diriswa jang ke mine ebe e ba tlosa ke ona mokgwa o ba lwile ene setso le kharatlo o re bontshitse ka yona gore di a sebetsa. So mathata le tlhakatlhakano e re bona mo platinum belt go na le ka mokgwa go leng ka teng, go na le bao ba na le go matla ene go bolelwa gape le matla a setšhaba kere. A re tshwanetse re tlhaloganye gore go amogwa matla ale gore go tsaelwa matla ale re na le ngwana le gore le gore ideology le tla nthusa go nagana dikgopolo tseo di leng teng tsele tsa kgale ke a feleletsa. So a re ba bile ba fa dikgosi matla ene jwalo ka jeko go na le gore ga ba re fe matla a gore o ka kgona le gore o fumane naga mo o batlang go ba teng ene ka jeko le kgale molao ole o ntse o bereka gore batho ke dithata tsa dikgosi ga ona matla a ileng a gago a ba a quota bontate Ogeno a ba bua ka gore o tshwantse o be le go ba le control ya dithata.
Ka bokhutswane Sonwabile o bua gore definition ya gore morafe re bitswa morafe community e re dinaile identity o kra gore rona a re kgone go itlhalosa gore re bo mang re setse re bitswa ba.
All right. Thank you very much, colleagues. Apologies again to those who are joining on the virtual platform. Just a reminder, we take a pause after the presentations in order to allow for translation to take place at the in-person venues. It's a mechanism that we are using to try and facilitate wider participation. I'm now going to move to the engagement portion of the plenary. So at this point, we're going to have a look at some of the comments and questions that have been posted in the chat. I'm also going to ask colleagues at the in-person venues to please look out for questions. If there are questions and comments from colleagues who are attending either in East London, Durban or Johannesburg, lithuba ngokulobuza imibuzo okanye mhlambi lokwenza ulonika uluvo lwakho ukuba ikhona into obufuna uyithetha okanye into mhlambi obufuna ikiphinde igxininise ukhulunyiswe kanguyive kahle lelo thuba ngoku abo bakhoyo eMonti naseThekwini naseGauteng kunisizo ninika ithuba uba ukhona umuntu onombuzo uba athethe kwabo abasijoinayo kwi-virtual platform yethu besicela niyibhale imibuzo yenu. So I'm going to take a look at the chat and have a look at some of the comments. There is a question from Innocent, and I think it's a question that that could go to anyone on the panel, but I'll direct it at you, Professor Mnwana. And the question is, what is the place of youth in this system? So you spoke to us about some of the challenges on the Platinum Belt. Could you speak a little bit to what the place of youth is as you see it? There is a comment from Uspoga's Chica to everybody. She says, or Spogazi says, that people living in the rural areas of the Eastern Cape have refused to allow mining in the Wild Coast because of what they've seen happening in other areas of the country. Mining has unfortunately left a lot of people worse off than they were before, although they were promised development. So again, perhaps Professor Mnwana, you could speak to that tension about the offer of development, the promise of development, alongside some of these challenges that you were speaking to that are taking place in the Northwest. Then there are some comments on the input from Professor Mnisi Weeks. There is some comments from Kenneth. Kenneth asks or comments about the amalgamation of customary law with a foreign system and notes that it will inevitably misdirect the intended purpose of the system. Remember, customary law is conciliatory while civil law is judgmental. Kenneth has also made some comments further up that part of the problem is that we view customary law in a Eurocentric way, and that has the effect of making customary law subservient to European civil law concepts. Using a constitution which is based on European laws distorts content and the objective of customary law, and that the danger with codifying customary law is that it will become static. I have been noted that there is a question in Johannesburg. So let's go to Johannesburg and take that question.
Okay. Let's ask questions based on the panelists who have shared their stories. Shirami, I see your hand. And baby.
Is there a question in Johannesburg?
Yeah, yes, we do have.
Okay, yeah. All right, thanks. My name is Shirami Shirinda. My question is on what Nwabile was saying about community sharing rules. In South Africa, even the courts are saying if you are a community, you have to be sharing rules of using the land. I've got a problem with that definition, of which if this conference can assist in getting it solved. Where I come from, there are people, majority of us, who own cattle and grazing. So I will see us as that small group sharing the rules of how we're grazing our cattle there. But we are staying with chiefs and other people who have got nothing to do with grazing. So are we saying we are community with them, or the community is only us who are grazing the land? Thanks.
Thank you, Joburg. So Joburg, I'm going to take one final question from Joburg, then I'm going to move to Durban, where there's also a question. Apologies, colleagues, I'm just trying to spread the opportunity. Please go ahead in Johannesburg.
Yeah, I'm Baby Makheledisa from Northwest. I just wanted to find out what is the judiciary and the law class of South Africa doing about these apartheid laws that continues to rule us, especially in rural areas. For an example, the 1927 Native Land Act and the 1952 Native Administration Act. So why are we still being treated differently like other people in South Africa? Thank you.
Thank you very much, Baby. Can I go to Durban and take the question in Durban, please?
Sibingelele, sibonge, ngingubhekisisa Khanyeza, kwadina bakubo emolweni la nje ngasePine Town. Sibonge umbuthano osiqoqelela. Inkinga engiyibuka sibhekene nayo sijahana nemithetho yase South Africa. So inkinga enkulu yethu iSouth Africa. Ngoba singayilungisa lemithetho siyilungisela abantu, asiyilungiseli thina, silungisela eSouth Africa. Ngakho iSouth Africa yizwe eliphethwe abantu abangazazi ukuthi baba kuphi. Ngakho ke ekuyisincomo kumina ukuthi lelizwe kufanele libuyele ezandleni zabanenilo okwabantu abamnyama. Ke inkinga yethu ukuthi sijahana nezinto zabo kufika. Iloko okumele ukuthi kushintshe ukuthi asijaheni izinto zethu ukuze zingasijahi. Njengamanje sijaha izinto zabo. Lezi zinto siyayijaha ziyasijaha futhi nazo. So sihleze sibaleka sihleze sikhala kanti izinto zethu ngeke zisijahe. Impilo esiphilayo kumele ukuthi siyishintshe ukuze singabi imakethe kubantu base South Africa. South Africa ikhona ngoba thina abantu abamnyama siyimakethe kuyona. Kanti mesiyeka kuba imakethe senze izinto zethu, imali esisebenzisayo akuyona yethu. Ulimi asinalo ulimi lokuxhumana eSouth Africa. So kufanele siqale ke senzeni izinto zethu ukuze singalokhu sibaleka, singalokhu sijahana nezinto esingazazi. Ngiyabonga Hlalo.
Siyabonga baba. Ngizocela ukuthi umuntu lapha eThekwini asinike a very, very short translation. Then I will take one more hand ukuba sikhona elantuke eThekwini. Then I'm going to come to eMonti. Sicela nje ukuqulelwa briefly that question or comment, colleagues.
My name is Plenary Khanyeza. Our problem is that we are imagining South Africa in a foreign language and in a foreign way of living. We must move out of a market-driven country. Let us imagine things in our own way of doing things.
Thank you very much. Umbuzo wesibini eThekwini ukhona? No, I'm going to move on then. Can we come to eMonti? The first hand from eMonti.
No, Lundi,
Is that a question from Durban?
yes.
Please go ahead.
Okay. Good morning. My name is Nonhle Mbutuma from Mbizana, Eastern Cape. Yeah, my question, it goes to Prof. He mentioned about the native land laws. What are the native land laws? This is where I need at least for him to elaborate that. And second thing, he talks about who has the power to decide or control when it comes to the communal land. That is the most important thing, because this is where we differ most of the time with the government. Because government always said to communal land is owned by the people. But that is a theory. Because government at the same time is them that they control and they decide, not us. If we decide, these mining companies, they come to our communities, we're supposed to decide to agree if we say yes to mining or we say no. But it's clear when the mining companies, they never come to us as the land holders to speak to us if we were welcoming the mining or not. They always go to the government, and government authorized that the mining company can go ahead. That means we are not controlling, the state is controlling, which is becoming a very problematic. And also, as we are talking about the bylaws or the customary law, in our rural setup, we have our clear bylaws, our clear customary law for many things. For example, if you get a site, we have our own bylaws. What are the processes you need to follow in order to get a site? But the same government, the same officials, is them that they break or they bend those bylaws. For example, we have indunas in our communities, we have Osbonda, we have everything. But for them, because they use land as something that you can buy it, when they go to our communities, they just avoid those laws that they don't exist. If somebody is rich, just go and speak to the chief and pay money and build the site. And who's going to respect those laws if our own officials, they are not respecting? Thank you.
Thanks very much, Ms. Nontle. Colleagues, my apologies to those who are on the virtual platform. We're not going to be able to take your spoken comments. Please do post comments and questions on the chat. Professor Mnwana and
Chair, you are on mute right now. Can you unmute yourself, please?
I was just saying thank you very much to Usis Nontle and apologizing to those who are on the virtual platform. We won't be able to take spoken questions. Can the first question in East London get ready? And just to ask that people please monitor the chat, Professor Mnwana and May Grace. Please keep an eye there. There are some questions to you. Ubuti Apa Monti, please go ahead. I'm only going to be able to take Izandles Bini Apa Monti nongolela ngenxa yexesha. Please go ahead.
Oh, enkosi mhlali ngaphambili zawuthetha ke anduzuguqula ilwimi. Ndifuna nje uqala ngokuhlomla kwesasigaba sokuqala kwenkqubo apho bekusaziswa abantu abasishiyileyo. Ndicinga uba baliqela abantu apha ephondweni abangakhange bakhankanywe. Ndingakhankanya nje ifemeli eye yasishiya kabuhlungu ngo-2020 leya kwa-April, abantu abadutyulwa bekhusela umhlaba, umama notata on the same day. So ngabanye awamaqhawe endicinga into yoba fanele sibakhumbule. Banintsi, kukho oomama ufani kwelaa cala secala, ootyanki nabanye. Now kukho izinto ezimbini endifuna ukuzikhankanya xa kuthethwa ngokuhluthwa komhlaba eluntwini. Ayizo mine kuphela ezibangela abantu ukuba baphulukane nomhlaba. Apha ephondweni kukho iphulo leenkampani ezinkulu ze-agriculture, ezinto bathi xa bezikhumsha zii-agribusiness, ezibangela into yoba abantu baphulukane nemihlaba. Abantu bakucentane ngomnye wemizekelo, apho kwafika inkampani bathembisa into yoba ifuna basebenzisane bazokwazi ukuxhamla emhlabeni ngokulima. Sithetha nje aba bantu babethenjiswe ngento yoba bazawuxhamla kulo mhlaba abaxhamle ngokubalwela into yoba bafumane umhlaba wabo back kuba inkampani ingene yaxela inkamela yangaphakathi yawugqiba yabakhuphela ngaphandle bona. Okwesibini, bendike ndaseLimpopo ndafumanisa into yoba kukho inkqubo yokuhluthwa komhlaba entsha eqhutywayo pha. Iinkosi zivumelana nabelungu ababekhutshiwe emhlabeni kwiindawo zabantu abamnyama into yoba abelungu mabathenge over lo mhlaba. So sizawufumana imeko yoba laa nto sasithi abantu bebenikwe i-13% yomhlaba, abelungu bayawuthatha kwakhona kwala 13 kwakulo mhlaba uyile 13% eLimpopo. So ndizama ubonisa into yoba le mcimbi wokuhluthwa komhlaba ubanzi wenzeka ngendlela. And eyokugqibela ile yefamily ezikwiindawo zamafama. Abantu abahlala abantu abahlala ezifama nabo basengxakini. Inabile ke yona ke iyenzeka kwindawo ngendawo all over iSouth Africa. Eyokugqibela ngaba bantu bafuna ukusebenzisa umhlaba basezidolophini. Umthetho obufanele into yoba uyabancedisa into yoba bafumane umhlaba. Kukho abantu abafuna ukulima basezidolophini. Sinempazamo yokucinga into yoba ulimo ne-farming yeyabantu basemaphandleni nasezifama. Kukho abantu abahlala ezidolophini abafuyileyo nabafuna ukulima. Kukho umhlaba kamasipala obufanele into yoba uyabancedisa. But ufumanisa into yoba le mihlaba iinkokheli zethu zopolitiko kulaa rhulumente olasemakhaya lunikezela ngale mihlaba kumafama amakhulu ingakumbi amhlophe. So zezinye zezinto ezinabisa lento yokuhluthwa kwabantu imihlaba nokwalelwa abantu amathuba okuziphilisa.
Umbuzo wesibini bengicela ungabi mde mntasekhaya.
Thank you very much. My first comment will be to Professor Wicks Ongekhoyo. I'm raising this on the basis of a statement that even though common law as well as customary law, the intention is to solve conflict between people. But I'm worried that even though there is a sameness in terms of what I'm saying, justice at the end, but sameness will never lead us to any common good. The reason is that the current customary law as it stands, even though we said it's revolving, it is still within what I will call a conduence or a channel of an English definition, which once again will give much more power in terms of common law. Interpretation as it stands of many things is defined on the basis of English, not on the basis of practice. So as long as we are stuck and want to give customary law a certain level of common law and any other laws, customary law by institution will always be looked down. So I'm worried, even if we said we need to amalgamate that. We rather build customary law, interpretation of it, and make it as an independent law, particularly when it comes to customary issues. The last issue, I want to raise an issue to Professor Mwan. In terms of projection of what you have raised about community and power, once again, I'm worried, as we have alluded, it has taken years under colonial system to define what is community. What today we know as villages is a design and interpretation fused into the practice. So anyone in this building is living a definition of a village in terms of the Western understanding than African, how much it will take to reverse it, and what are the ways of reversing it?
Thank you very much. Colleagues, in the interest of time, ndizovala ngelishwa ndiyaxolisa. I'm going to quickly translate the input from Dr. Ngapai, and then I'm going to ask Professor Mwana and Meg Grace to respond. Dr. Ngapai was flagging the fact that there were some additional families and additional comrades who had passed, and he particularly mentioned the April family, Mr. and Mrs. April, who were shot. They were both activists trying to protect land rights. He also spoke about Mamufani and the Gyangi family. The inputs that he was making were to highlight that mining is not the only cause of dispossession, but here in the Eastern Cape, there are challenges with the advancement of agribusiness. And he gave the example of a community in Glendani where they engaged with a company that runs an agribusiness venture, and what had been promised as an opportunity for community benefit has now become a struggle to assert and protect their land rights. He also spoke about experiences in the Limpopo province where people are being dispossessed through the collusion of land sales involving traditional leaders and sometimes involving people from outside the community. And lastly, he made mention of the challenges of farm workers, just highlighting the point that farming is an activity that should be supported at the local level and that there should be support from local government, but that is not forthcoming. Meg Grace in Joburg, I'm going to come to you for a response or a concluding thought, and then I will move to Professor Mwana. Johannesburg, Meg Grace's concluding thought. Johannesburg? Hello, Johannesburg, are you there? We're not hearing sound from Johannesburg. Is it just us?
Yeah, I'm not hearing any sound either. Letu, can you arrange the sound, please?
Johannesburg? Okay, while we try and address the Johannesburg sound issue, can I go to Professor Mwana? So Nwabila, on your end, there were a couple of questions, some particular engagements around the points you were making in relation to community and ideas of homogeneity. Could you give us the best summary response?
Tlogelang go fa magosi dithata tsa dithoto tsa rona. And magosi a mangwe a dirang dilo tse ke magosi a di-regent kona re fang bothata. Puso ba akanyang dilo tsa morafe mo lefatsheng la rona. Re na le mafatshe go faragana re farologana fela ka dipuo. Mme morafe o mongwe le o mongwe o na le se leng sa bona ka bo bona. Tlogelang gore le nne le dikgosi tse le tjang le tsona le le puso le be le sa kgathalle gore go diragala eng. Gona ga le ka bona o nna ke tswang teng le ka se ka la dumela gore ga go nna batho ba blaster le role le tša tlhaga ga gona fa e leng gore dikgomo di ka fula teng ga gona le fa e leng gore bana ba ka tshameka teng ke le role fela ga monako e tlo tlang re tlo thuswa ke bomang ditlhare di seyo tse di tlo re alafang ge re tla be re na le di-asthma le di-TB dilo tsotlhe tse dikgomo tsa rona di nwa maswe magosi ga re tlhokomele ebile ba environment re kopa gore ba nke ba tseye matsapa ba tsamaye mo batho ba nnete ba bona gore go diragala eng ba tlogela go nna fela kwa diofising mme ba re senyetsa ra ikopela puso ra kopa we are appealing to you leave us with our forefathers' properties. Some of this land has been bought by the money. It does just grow up for nothing. Please, government, go and sit down and think about us. We elected you not to be like what you are today. We have been expecting more green pastures, But now we are back to where we were not supposed to be because of you, government. We are pointing at you, our fingers. I thank you. Matla.
Ngosi Meg Grace. There is a translation of Meg Grace's input in the chat, so I'm not going to pause for translation. I'm going to move straight to Professor Mwana for his responses and a closing thought.
Colleagues and Chair, I'm not going to do justice to these very interesting questions that have been raised because of time. And at some point, I will share my paper for some people who have asked for it. It's still a draft. I'm waiting to finish it. But I think that the broader point, starting with what Bonani and other participants have asked around the principle of community, as opposed to what has been dominant, looking for a definition of community. I think it is possible, Bonani. It can still be done. We need to ask the right question. Perhaps we could start by asking, in what aspects of social and economic life does the principle of community, take effect, in the lives of rural residents? For instance, how do you define, for instance, what people do in urban areas, in the townships, where they come together to fight crime as the neighborhood watches, whatever, and they take turns without being paid to make sure that there's security and protection in their areas. So that means that they have a principle of community in some aspects of their social lives, and they're applying it successfully. So why then do we tend to use the notion of community as a definition from above to define rural residents and to confine them into identities that at times they reject and make them subject of local chiefs and disempower them when it comes to their land rights? So that's the point I'm making. Many interesting questions. For instance, there's an interesting question about the place of the youth in these struggles. I found the youth quite involved, and I've really observed over the years the contradictions that exist, especially in context. Well, I'm just going to make one example. In Limpopo, where rural residents were relocated from one place to the other, and young people were promised, among other things, jobs, but there were no plots of land allocated for them. Because as you would know, as young people grow, they eventually come of age where they will be able to get a piece of land through the customary systems. But in the place where they were being relocated, where the mine relocated people, it didn't cater for this. It created a township instead of a village. And so many young people were left out. And many young people have been victims of imprisonment, when they protest against mining. And quite many of them have been promised jobs and other benefits from mining that never really materialized. And actually, the situation around the youth, on the platinum belt in these areas is quite, is no different from other youth elsewhere, except that they are involved in daily struggles for survival and being subjected to harassment and even arrest in times when they raise grievances. So this connects to the question of the promise of development. Well, the promise of development in South Africa has not materialized from mining, despite the vast amounts of mineral resources that have been extracted from this country. Sadly, it hasn't materialized, just as it did during apartheid. Even before apartheid, Black people have been excluded. And now what is even more sad is that mining occurs now in the former homeland areas, where the majority of Black people live. They are being dispossessed, relocated, and there's very little benefit to the ground, and on the ground. And some of them are even being labeled as shareholders. I'm not sure how ordinary villagers, impoverished villagers in the Bafokeng community and in the Bakhatla community and in the Bapuba Mokhale community are shareholders in these mines, because most of them are poor. Most of them depend on social security systems, which are often called social grants in South Africa. But the chiefs have all these big business portfolios and they take all these big decisions. They are on the board of directors in these mining companies on behalf of rural residents who benefit nothing from mining, in my view. You know, so these are some of the issues that are quite important. I mean, that have been raised. Nonte, you raised, what were the native land laws? Very important question. I think we need to understand, you know, native. When we talk about native land laws, we usually refer to the 1913 and 1936 Act, you know, those land acts. However, those were moments of formalizing of African dispossession. It had happened long time ago. You know, many Africans were taken away from land before those times, you know. But at that time, the remnants of Africans who were still on land and farming productively, whether they were sharecroppers or in whatever form of arrangements, they were now pushed out of land. So Africans were pushed out of any form of productive land unless they were just laborers on the land. That is how they could exist, you know, on the land that was productive. I mean, these were the acts that formalized that formalized dispossession. And I also want to drive this point to my observation, because through those acts, Africans, I mean, most of the land, I mean, the Africans were confined into these reserves, which then fall under the Bantu standards, you know. And even today, those lands are held by the state. That is why Africans have no rights, you know, rural communities have no rights, I mean, have no power when that land is targeted for mining investment. They have no power to defend their rights because the state holds that land, you know, as a trustee. And then it then decentralized some of its power to local chiefs. And the customary rights holders on the land become so disempowered. That is why, I mean, some communities have had to go to the highest courts in the land to defend their rights, which was not even necessary in a democratic society. But it has happened, sadly, and many people are still dying to defend those rights, even today. So I think that's a very important point. I mean, it connects to your question, Andre, about who has power to decide. You know, customary land rights holders, villagers, should have power to decide, not the state, and not the mining companies, and not the local chiefs, in my view. And I think that I've written extensively to that effect. Ashrami raised an interesting question about rules and community sharing. I wasn't quite, I didn't really get it quite well, my brother. I'm really sorry about that, but I'm happy to engage with you after this. You know, I think I really didn't get that question quite well. I'm sorry, but I think that was an interesting question about the rules of sharing. I don't want to approach it in another way, but I think that any rules of sharing the land, I'll come back to, I don't know whether my first point, which emphasized that we should depart from the fixation with defining communities, you know, towards a principle that defines, that helps us to understand. We need to do a study to understand which aspects of African social and economic lives, I mean, how does the principle of community applied in different aspects of African social and economic lives? And then we could decide on how much power do units and even individual or groups of Africans have over particular pieces of land, or how and or however land is defined, whether land is used for arable production, or land is used as a residential land, or land is the commonage for grazing. So anyway, so I really would be interested for you to elaborate, I mean, even privately on your questions, Ram. I'm sorry if I've not answered it directly. Thanks.
Colleagues, as always, there is never enough time to engage and unpack these questions. I recognize also that in some of the Q&A, there hasn't been time to do a similar translation process. I am going to bring our opening plenary to a close. I would like to extend sincere thanks to the speakers, Siyabulela kakhulu, Grace Maledu, Professor Sonwabile Mnwana, and in absentia, Professor Cindy Somnisi Weeks for agreeing to kick off the conversation. Ndiyathemba ukuba noko basinike izinto ezikhe sizihlalutye sizicinge njengoba siqhubekeka sincokola kwezi ntsuku ziseleyo. When we return from the tea break at 11:40, we will go straight into the plenary sessions. So, sorry, the parallel breakaway sessions, not plenary. For those of you who are joining us on the virtual platform, you can either stay on the platform and just mute yourself and take a tea break and a stretch break, or if you log off, you'll log back onto this platform. Once you've done that, you will see at the bottom of your screen, you will have an option to select rooms. There are 2 parallel breakaway sessions. Panel 1A is the dispossession and mining the sacred. It's the panel chaired by Umbongiseni Buthelezi and has speakers Dineos Kosana, Mbuso Ngosi, and Simon Gash. So that's panel 1A, dispossession and mining the sacred. Panel 1B, the second option, is dispossession disguised as regulation. It's chaired by Zenande Boy and has speakers Kolos Ndombeni, colleagues from the LRC, Cecile, David Mason, and Colin Lowe, and then has Speaker Pilile Mbata as well. So you will make a choice to go to either panel 1A or panel 1B, and you will be directed